Hi guys, welcome back to another episode of Lawyered Up. I am your host, Jared Moore. And Lawyered Up is the program where we try to weave through the labyrinthine maze of tribal law and courts to find some modicum of justice or relevance. So, with that being said, today we have a huge program. It's going to be a long program because our main meat and potatoes case has been about 16 years. This case has been going on. But before we get into that, there is an update in one of the cases that's at the MCN Supreme Court. And I'm going to pop up our little window here and we'll get started. If you guys have any questions, pop them in the chat. As you all know, I'm not a lawyer, so some of the questions I won't be able to answer, but if I know the answer, I'll try to answer it for you. Here we go. Okay, so we are on the Mvskoke Creek Nation Supreme Court website. We're going to go to the current docket, and we're going to be looking at SC 2024-05 in the matter of the constitutionality of NCA 24-077. And there's been a new post here. Let me zoom that in for you guys. There's been an order setting oral arguments. Now, if you guys don't remember what this case is about, the Friedman case that is also on the current docket here, let me back up one, was put on hold to hear whether NCA 24-077 is constitutional because NCA 24-077 gives the legislature and the executive branch the ability to appoint special justices when a certain number of justices recuse from the Supreme Court in certain cases. So let's go back to where we were. We'll go back in. Order setting oral argument. Let me zoom in here. So it's hereby ordered that in accordance with Title 27, Appendix 2, Rule 28, oral argument is scheduled for Friday, January 10th, 2025 at 10 a.m. Central Standard Time. So it says oral argument will be conducted via Zoom video conference. The clerk of the Mvskoke Creek Nation Supreme Court will provide all necessary Zoom meeting, yada, yada, yada. Let's go down to the part that's important for us. It says the court, here, let me highlight that for you guys. I can't. The court will live stream the January 10th, 2025 oral argument on the court's Facebook page, and then it gives a link there. And the video will remain on the page for the general public to view until close of business January 10th, 2025. Please ensure that your lead counsel's contact information, etc., etc. So they're going to stream it to their Facebook, but here's the other part. If we scroll down here, we're going to, where is it? Here we go. This is the problem for us here. It says courtroom etiquette. If you look there in the middle, it says you are participating in a court hearing. Please dress and utilize the same general decorum that would be expected in an in-person setting. Participants shall remain silent until invited to speak to the court. All audio and video recording, photographs, and/or reproductions of the virtual meeting and oral argument are strictly prohibited. Okay, why am I talking about that? So we've decided here that that part of the order, if we restream what they're streaming on the court's Facebook page to our YouTube page, we could be violating that part of the order. So we're not going to do that at this time. If we get some clarification from the court or something in the future that says it's okay for us to do that, we'll do it. But as of right now, the only place you're going to see these oral arguments is going to be the day of on the Creek Nation Supreme Court's Facebook page, and it's only going to be up until the end of the day, which I'm assuming is 5 p.m. So you're going to have a little window there where you could watch it. And again, if you don't remember what this case is about, it's about the law that was created that gave the Creek Nation legislature and the executive branch the ability to appoint special justices in cases where justices recuse from Supreme Court cases, right? And the constitutionality of that law has been challenged, so they're going to hear oral arguments. Okay, so that's the update part of our program. Let's go back to my window here. And today we're going to be talking about Thlopthlocco Tribal Town versus Roger Wiley, Richard LeBlanc, Adam Adams III, and so on and so forth. These are all justices in the Mvskoke Creek Nation. This case has a really long history. I'm going to use I should back up and tell you guys, if you want to read along or read the documents that I'm reading in this history section, there's a link in the description of this video. You can click it and you can read them all you want. Okay. So what this is that we're looking at here is the opinion in the Northern District of Oklahoma that's at the end of this long saga. And this opinion and this order was appealed to the 10th Circuit. After I go through the history part, After I go through the history part, we're going to watch the oral arguments in the appeal to this opinion, if that makes any sense. I hope it does. But let's go through the history part, and that will catch you up with where we are with the case, and then we'll go to the oral arguments part. Okay, so as we see here, this opinion says this action addresses 16 years of litigation between the Thlopthlocco Tribal Town, the judges of the Mvskoke Creek Nation courts, and other members of the Thlopthlocco Tribal Town arising from an attempted coup d'etat after Thlopthlocco Tribal Town elections in 2007. Okay, so I'm going to go on past the decision here, and let's go on down and get to the background. Okay, so I'm going to summarize some of the background. If you guys want to read it, you can go in and read it all. But just in a nutshell, if you're not familiar with how the Creek Nation was structured before they adopted a centralized government, the Creek Nation was made up of many tribal towns. And even today, the ceremonial grounds are basically like the tribal towns, right? Before the Civil War, that's when the Creek Nation centralized into a main government, right? The tribal towns were still functioning and still very important, and even up today, there are tribal towns. But Thlopthlocco was one of these tribal towns, and in the, what year was that? Let me look at my paperwork here real quick. Yeah, I believe it was 1936. Oklahoma passed the Oklahoma Indian Welfare Act. And what that did was it allowed tribes, if they created their own constitution, they could apply and get federal recognition. And Thlopthlocco was one of those early tribal towns that applied and got federal recognition. And the reason I mention that from a historical standpoint is because the Mvskoke Creek Nation has federal recognition, and Thlopthlocco Tribal Town has federal recognition. And from the eyes of the federal government, that means they're two separate federally recognized tribes. Okay, let's keep going. Let me pop my screen back up. This section here just talks about the history of that, and the doll was. I'm going to jump ahead because there's a lot of information here. This part, let's start from here. We'll try starting from here. Today, the Thlopthlocco Tribal Town has a 10-member business committee in which it vests the power to govern. The business committee is comprised of 5 elected town officers and 5 advisors appointed by the elected officials. Thlopthlocco Tribal Town holds elections every 4 years. If a position becomes vacant between elections, the remaining elected officials have the authority to fill the vacancy. Why is that important? Let's go on down here. Factual and procedural background. In June 2007, Nathan Anderson was elected town king of the Thlopthlocco Tribal Town and attempted a coup d'etat by declaring himself the only legitimate elected official and deeming all other offices of the Thlopthlocco Tribal Town's business committee vacant. The Thlopthlocco Tribal Town filed an action in Mvskoke Creek Nation District Court against Anderson for declaratory and injunctive relief. The Thlopthlocco Tribal Town adopted a limited consent and waiver of sovereign immunity that excluded election disputes. So if you guys aren't familiar from our other stuff, for a sovereign tribal government to go into a court that's not their own, well, even then in that situation, they have to sign a waiver of sovereign immunity. Sovereign immunity makes them immune to any type of suit or anything. So they have to waive that to go in there. Sometimes when you see loan agreements between tribal governments and banks, there will be a limited waiver of sovereign immunity in that loan agreement so that the bank can take actions against the tribe if it doesn't pay what it has to pay to the bank. Anyway, this is a side note. But let's keep going through the history. So, this waiver of sovereign immunity that Thlopthlocco had in this particular case excluded election disputes. So the Mvskoke Creek Nation District Court determined initially that it lacked jurisdiction to hear the matter and urged Thlopthlocco Tribal Town to resolve the issues internally. The Mvskoke Creek Nation Supreme Court reversed the Mvskoke Creek Nation District Court's initial decision, however, holding that the Thlopthlocco Tribal Town was subject to the jurisdiction of the Mvskoke Creek Nation courts because it is a Mvskoke Creek Nation town. That's why we were mentioning that earlier, because what the Supreme Court of the Creek Nation said is they're subject to our jurisdiction because they are a tribal town. Okay. I should also mention, this case, the judge in the district court at the time that this case was going through was my dad, Patrick Moore. He was the judge out here for a long time. He hasn't been the judge in the district court here for a long time too, and this was taking place in 2007, so many years ago. All right, let's go back to that's just a disclaimer. What happens next? The Mvskoke Creek Nation Supreme Court reversed the Mvskoke Creek Nation District Court's initial decision, however, holding that the Thlopthlocco Tribal Towns... Oh, we did that? So after the Supreme Court issued a decision saying that Thlopthlocco was under our jurisdiction, Anderson filed a cross-claim against the business committee members on grounds of election fraud and violation of the Thlopthlocco Tribal Town's constitution. Then the parties resolved some of the issues by removing Anderson from office according to the Thlopthlocco Tribal Town's constitution. However, Anderson continued to pursue his cross-claims. The Thlopthlocco Tribal Town filed a motion to dismiss its suit and withdrew its waiver of sovereign immunity. But the Mvskoke Creek Nation District Court denied the motion, holding that it had jurisdiction to hear Anderson's cross-claims despite the Thlopthlocco Tribal Town's withdrawal of its waiver of sovereign immunity. Okay, so did you guys get that? Thlopthlocco waived their sovereign immunity, except for election disputes, to take Anderson to court at the Creek Nation, right? The district court said, we don't have jurisdiction. The Supreme Court said, yes, you do. And then Anderson filed a suit against the business committee in the Creek Nation court. And for that suit, because it had election claims, the Thlopthlocco withdrew their waiver of sovereign immunity, so they couldn't be sued by him. But the district court said, no, you can be sued because of this other waiver. Okay, just trying to clarify that because this is going to get complicated. All right, let's go back to the documents. The Thlopthlocco Tribal Town filed an interlocutory appeal with the Mvskoke Creek Nation Supreme Court, which denied the appeal and held that under tribal law, the Thlopthlocco Tribal Town was part of the Mvskoke Creek Nation. What interlocutory appeal is basically saying is they're asking the Supreme Court, the Creek Nation Supreme Court, can the district court do this basically? We have a waiver, why is this happening? And the Supreme Court said yes, that you're part of the Creek Nation. So in a new election cycle in 2011, the Thlopthlocco Tribal Town excluded Anderson and other individuals from the election ballot. This led to Anderson and the other individuals filing another cross-claim against the Business Committee. The Business Committee filed motion to dismiss for lack of jurisdiction, but the Mvskoke Creek Nation District Court denied the motion and ordered that the Thlopthlocco Tribal Town proceed with the election and include Anderson and his co-plaintiffs on the ballot. The Thlopthlocco Tribal Town filed a lawsuit against the Mvskoke Creek Nation's judicial officials in the United States District Court, Northern District of Oklahoma. So what they were trying to do with that suit is stop the Creek Nation courts from exercising jurisdiction over Thlopthlocco Tribal Town elections and procedures. The district court, and when they say district court here, they're talking about the Northern District of Oklahoma, dismissed the Thlopthlocco Tribal Town's lawsuit for lack of subject matter jurisdiction and granted the MCN judicial officials' motion to dismiss. The district court held that the Mvskoke Creek Nation's judicial officials were entitled to sovereign immunity and that the Thlopthlocco Tribal Town failed to join indispensable parties and exhaust its remedies in the Mvskoke Creek Nation courts. Just a side note here, this indispensable parties basically says that there were some other people that were involved in the happenings of these lawsuits that weren't included in any of the filings, and that sometimes the court will say you need to go back and this case needs to be reheard with, and you need to enjoin these indispensable parties. They're indispensable. You got to have them as a part of this lawsuit. So just a side note there. The Thlopthlocco, let me scroll down. The Thlopthlocco Tribal Town appealed the district courts, and again, this is the Northern District of Oklahoma District Court, decision to the United States Court of Appeals for the 10th Circuit. Okay? On September 13th, 2014, so that's where we are on the timeline. We've gone all the way from 2007 to 2014. The 10th Circuit Court of Appeals reversed the district court's decision, concluding that the question of whether a tribal court has jurisdiction over a non-member tribe should be decided under federal common law and is within the subject matter jurisdiction of the court. Let me pause really quick. And so some of these terms are obtuse or is just, like most people don't know what they are, and I probably don't know what they are. But in a nutshell, what's happened here is, the Northern District of Oklahoma said, we don't have jurisdiction. And so that got appealed up to the 10th Circuit, and the 10th Circuit said, you do have jurisdiction under federal common law. Okay, let's keep going. The 10th Circuit Court of Appeals concluded that Thlopthlocco Tribal Town pled sufficiently that it is a separate and independent Indian tribe beyond the reach of the Mvskoke Creek Nation's jurisdiction. The 10th Circuit Court of Appeals issued a remand to the District Court, this is the Northern District of Oklahoma, for additional proceedings to join necessary parties and abate further proceedings until the Thlopthlocco Tribal Town exhausted its tribal court remedies. Okay, what does that mean? So the 10th Circuit is kicking the whole thing back down to the Northern District Federal Court of Northern District Oklahoma Court and saying, you guys need to hold off on the proceedings in the Northern District Court until Thlopthlocco exhausts their tribal remedies, which means they got to come back down to Creek Nation. Okay. Whew. Are you guys confused yet? So at this point, they included the MCN judicial officials in the motions. They sought to join 6 Mvskoke Creek Nation judicial officials, as well as Anderson 1 defendants and Anderson 2 plaintiffs. So you'll see this come up again and again, Anderson 1 and Anderson 2. What that is if we go back in the time machine of what we just talked about, Anderson 1 is Anderson's first countersuit against the business committee, and Anderson 2 is Anderson 2 is the second case. I'm getting confused. It'll tell us in a second. I'm going to go ahead and scroll down. Okay. On December 30th, 2014, the district court abated further proceedings and remanded the matter to tribal courts. The district court also entered orders joining members of the Mvskoke Creek Nation judiciary and staying the remainder of joiner issues until after tribal exhaustion was complete. Okay, on May 24th, 2021, the Mvskoke Creek Nation District Court issued its decision. Now you might notice there's a big gap of time that decision came out, and that's going to be discussed in the oral arguments that I'm going to play for you guys later in the program. So, but keep that in your memory. The Mvskoke Creek Nation District Court dismissed Anderson 1, finding that Anderson was no longer a credible threat to plaintiff's government, thereby making the case, the plaintiff is the Thlopthlocco Tribal Town, thereby making the case no longer justiciable, which means that there's no case to be heard. Mvskoke Creek Nation, that's just a story. The Mvskoke Creek Nation District Court held that Thlopthlocco Tribal Town could not rely on sovereign immunity to remove Anderson and other individuals from its election ballots. The Mvskoke Creek Nation District Court concluded that if it had both personal and subject matter Mvskoke Creek Nation District Court concluded that it had both personal and subject matter jurisdiction over Anderson 2. On appeal, the Mvskoke Creek Nation Supreme Court held that Thlopthlocco Tribal Town is entitled to sovereign immunity in the Mvskoke Creek Nation courts. The Mvskoke Creek Nation Supreme Court also held that the Thlopthlocco Tribal Town could submit itself voluntarily to the jurisdiction of the Mvskoke Creek Nation courts, concluding that the Thlopthlocco Tribal Town waived its sovereign immunity in Anderson 1. The Mvskoke Creek Nation Supreme Court affirmed the Mvskoke Creek Nation District Court's decision to dismiss Anderson 1 and held that the Mvskoke Creek Nation courts had exercised proper jurisdiction over the case in its entirety. Regarding Anderson 2, the Mvskoke Creek Nation Supreme Court reversed the Mvskoke Creek Nation District Court's decision, holding that Anderson's cross-claims extended outside the scope of the initial injunction action. The Mvskoke Creek Nation Supreme Court held that the Mvskoke Creek Nation courts did not have jurisdiction because the Thlopthlocco Tribal Town's waiver did not extend to the issues in Anderson 2. Therefore, the Mvskoke Creek Nation Supreme Court reversed the Mvskoke Creek Nation District Court on its ruling regarding Anderson 2. Neither tribal court addressed the issue of whether the tribal town could withdraw its waiver of sovereign immunity under appropriate circumstances. Okay, so the tribal town now returns to the district court, and that's the Northern District of Oklahoma, seeking a declaratory judgment that it enjoys sovereign immunity in the Mvskoke Creek Nation courts and may, if it chooses, consent to such a jurisdiction, and 2, it may withdraw its waiver of sovereign immunity and consent to jurisdiction under appropriate circumstances. Defendants would be the Mvskoke Creek Nation judges, filed a motion to dismiss for lack of subject matter jurisdiction, arguing that this case is moot and that any opinion by this court would be advisory. Okay. I'm going to try to summarize this as best that I can. So what happened is, after all of the ping-ponging of the case, up and down and all over, right? Earlier, I was telling you guys that when the case went to the 10th Circuit the first time, the 10th Circuit sent it back down to the Northern District of Oklahoma court and told them to hold off until the Thlopthlocco Tribal Town had exhausted its tribal tribal remedies, tribal court remedies, right? And then after all that was done, it went back up to the district court, Northern District of Oklahoma, and that's this opinion. So that this opinion that we're reading right now is the judge's opinion when it got back up there after exhausting its tribal remedies. And the opinion that this judge gave is that they have they have sovereign immunity, and they can have a waiver, and they can also retract their waiver, right? And so the oral arguments that we're going to listen to in just a second are the Creek Nation arguing some various points, Creek Nation judges, but they're cloaked and they're trying to say that they have sovereign immunity under the nation, right? And what they're saying is, number one, the Supreme Court of the Creek Nation said that Thlopthlocco Tribal Town has sovereign immunity and everything. So this Northern District opinion, this Northern District case is moot now because they said you guys have sovereign immunity and we don't have the jurisdiction, right? And on the other side of that, the lawyer for the Thlopthlocco Tribal Town is trying to argue we need some type of guarantee, we need some type of ruling that says we have sovereign immunity. Otherwise, we aren't going to want to file any cases in tribal court. It's going to be hard for us to get any justice because we'll be worried if we file in tribal court that they won't allow us to withdraw our waiver if we have to withdraw our waiver, okay? So those are the two positions that are going to be the arguments. Now, I've got to make some disclaimers here because in the oral arguments, there was a situation where Nathan Anderson had sent Mvskoke Media a notice, and he claimed that he was a spokesman for the Thlopthlocco Tribal Town. And we ran it, and then in the process of double checking that and doing due diligence on that, we contacted Thlopthlocco Tribal Town, and they said he's not with us, he doesn't have anything to us, and it was a big thing. We had to issue a retraction. If you want to read that whole saga, which is is mentioned in the oral arguments here, but it's not like fundamental to the oral arguments. But if you want to read those posts, there's a link in the description of this video. You can go read it on Mvskoke Media and see what happened. Okay, so that's the disclaimer part. Now, before I go any further, I don't see any questions popping up in the chat. If you guys have any questions while I play the oral arguments, pop them into the chat. What we're going to watch now is yesterday, the oral arguments, the audio from the oral arguments was live streamed. And it's in the 10th Circuit hearing the MCN Judges appeal of the decision, the opinion I just read to you guys, okay? And we just did the history part of it, really. The opinion is going to get debated right now. So with that being said, thanks for tuning in, you guys. I'm going to let the video play, and then after it's over, I'm just going to stop the stream. So I will let you guys say, happy holidays. I hope you guys have a great Thanksgiving. I myself will be on vacation next week, so there probably won't be any videos posted. And I think I've covered all of my points. Let me look and make sure I didn't leave anything out. Everything looks good. All right, let's listen to the oral arguments. And remember, this is just the oral arguments. The decision in this appeal has not been issued yet. All right. Let's take a look.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
All right, looks like everybody is ready. Let's call 24-5011 Thlopthlocco Tribal Town versus Wiley. You may proceed.
Thank you, Judge Timkovich, and may it please the court. I'd like to reserve 3 minutes for a rebuttal. One central fact.
Please identify yourself.
Sorry, Riaz Kanji.
Thank you.
For the Mvskoke Creek judicial officers. One central fact informs the proper resolution of this case on appeal. Since this case was last year, and as a result of the exhaustion of tribal court remedies ordered by this court, the Mvskoke Creek Nation courts have ceased to exercise any form of jurisdiction over the tribal town. The Mvskoke Creek Nation District Court dismissed one of the two pending cases against the town in May of 2021 a decision which the Mvskoke Creek Nation Supreme Court affirmed in early 2022. And in that same opinion, the Mvskoke Creek Nation Supreme Court ordered the second of the two pending cases dismissed as well. So as a result, there are now no cases pending or impending in which the Mvskoke Creek Nation judicial officers are asserting any form of authority over the tribal town, which means that the court below should have dismissed this federal action for either one of two independent reasons. First, because the Mvskoke Creek Nation judicial officers enjoy sovereign immunity from the town's federal suit. In 2014, this court properly recognized that the suit could proceed under Ex parte Young, because at that time, the town alleged an ongoing violation of federal law in the form of the assertion of judicial jurisdiction over it. But now that key jurisdictional fact has changed, and the basis for Ex parte Young jurisdiction has evaporated.
Would you agree that the 2014 decision was, the understanding that we had there was it was about the injunctive relief claim?
I think it spoke largely to the injunctive relief claim. It also applied to the claim for declaratory relief, in that you can state a viable claim for declaratory relief under Ex parte Young if you are alleging an ongoing violation of federal law.
So why isn't the component that we didn't speak to so robustly in the 2014 case, the declaratory relief claim about the, which is the central claim here, still alive?
Because the claim for declaratory judgment relief, if I understand the question, that is governed by the same principles, whether we're talking about Ex parte Young or mootness, and I'll take those in turn. Under Ex parte Young, in order for the district court to issue a valid declaratory judgment, that judgment has to be speaking to an ongoing violation of federal law. Once there is no longer the actual or imminent threat of a violation of federal law, there's no basis for carving out an exception to the judicial officer's sovereign immunity. At that point, they're fully cloaked in the nation's sovereign immunity. When the judicial officers ceased to exercise jurisdiction in 2022, there is no other allegation of a violation of federal law that the tribal town has stated. Nowhere in its complaint can you find any allegation of a violation of federal law other than the exercise of jurisdiction over the town.
So it seems to me like that the ex parte Young argument and the exception to mootness of voluntary cessation kind of dovetail, in the sense that the argument is that, you dismiss this action and you're no longer exercising jurisdiction over us again, but you haven't said that you recognize that we have the ability to withdraw a waiver of sovereign immunity. We have to use your courts because we don't have our own courts, and we don't have any comfort that you're not going to do the same thing again as new cases arise. So that could fall under an exception to mootness, which is the voluntary cessation and the burden, by the way, is on the person who ceases to prove that there's no risk that it's going to happen again. And it also brings in sort of the ex parte Young, because if you have this concern about your jurisdiction, exercising jurisdiction over you when you have immunity, that would be a federal question. So that's a long question, but hopefully you understand it.
I definitely understand. There's a lot packed into that, so I will do my best to unpack each step. First, on the voluntary cessation exception, the key there is that exception applies when there's been a unilateral action taken by the defendant for the purposes of evading jurisdiction, for creating mootness. And those conditions don't apply here. First, the Mvskoke Creek courts not engaged in any unilateral action. They exercised their responsibility to decide the case pursuant to an order from this court that tribal court remedies be exhausted, and they decided the case in front of them at the behest of the parties to the case. So there's no unilateral action, and that's what this court has talked about in the Washburn University case, for example. That's one of the requirements. Secondly,
They dismissed the case.
but they
Found it
dismissed,
moot.
absolutely, Your Honor, but they dismissed the case because they examined whether there was a basis for the continued exercise of jurisdiction, and they found that there wasn't, so that they were exercising their judicial responsibilities, and I think they were being very responsible in doing it.
Okay, also, their order is kind of a little difficult to follow, or at least for me. It looks like they affirmed the tribal district court's finding that you couldn't withdraw your waiver.
Well, I think I think ultimately, and I understand what you're saying about how they addressed that issue, they ultimately left it open. And that's what Mr. Salem himself has said in his briefing. The district court, the tribal district court, the holding of the district court was that the case was no longer justiciable as a practical matter, which I think is essentially a form of saying it's prudentially moot. And then the Mvskoke Creek Nation Supreme Court affirmed that holding and really limited its decision to that. And of course, deciding a case on justiciability grounds is a perfectly permissible way to resolve a case. They resolved it on jurisdictional grounds, so there was no longer a live case or controversy. And as a result, the courts are no longer exercising any jurisdiction over the town. Now, the other part of your question was, you said, well, that leaves this issue about, well, what happens in the future if the town waives its immunity and then seeks to withdraw its immunity? And that was the basis on which the court below here found the case to not be moot. But I'll address that both.
But it did it on a different exception. It did it capable of repetition but evading review, right?
Well, it said, I think the district court here said two things. First, the case is not moot. The district court said it's not moot because there's a live case, was the phrase that the district court used, because there's still this issue out here. But that was fundamental error for several reasons. First, as this court has said, it said it in the Park County case, for example, almost any time that a case is dismissed for mootness, there are issues left to be resolved. But they're left to be resolved in future cases. The case or controversy requirement means they cannot be resolved in the instant case when the case or controversy has disappeared.
But wasn't the issue that was left unresolved here sort of the whole case at the end of the day?
Well, no, I don't think so, Your Honor, respectfully. There were a lot of issues packed into this litigation over time. There was the question about...
Well, I'm talking about just the withdrawal, the ability to withdraw consent was at the heart of the jurisdictional challenges. Was it not?
I would say fairly, it was one of several key issues. There were issues about whether the Lapides rule, the rule that once you invoke the jurisdiction of a court, in federal court, of course, the rule is that once you invoke the jurisdiction of a court, if you're a state, for example, whether you can withdraw that in fairness and equity. So there was that issue. There was the issue about whether the counterclaims fell within the scope of the case as it was brought. There was the issue originally about even...
Anderson 2, isn't it?
Sorry?
Is that Anderson 2? Whether the counterclaims fell within the scope, whether an election issue would be within the initial waiver of sovereign immunity?
It was Anderson 2. It was also Anderson 1, because in Anderson 1, there were counterclaims brought by Mr. Anderson about the election issues itself. There were issues about who properly spoke for the town. So there was actually an awful lot for the tribal courts to work through. But I think the key is this: in the Shell versus Oxy case, this court in 2016 said that the possible effects of a judgment on hypothetical unfiled future litigation are not a legally cognizable interest that will defeat mootness. And that's the only claim that the town has here, is to evade mootness, which is, as the panel said, is the town is claiming, well, in the future, there might be a case, and think about all the causal links in this chain. There might be a case that where we go into the Mvskoke Creek courts, we waive our immunity, we then withdraw that waiver at some later point in time, and the courts refused to honor that waiver. That's,
But the hypothetical future case, an exception to that is the voluntary cessation exception. So if we were to say, geez, you know, the tribal courts were really kind of jerking around these people, 5-year delay in the district court, and then it finally gets, after we say we could really use some help on this, goes to the Supreme Court, and the Supreme Court says, it's moot, and doesn't decide the issue. We might look at that and say, you know what? That might be a little bit suspicious, and they are in this court. It's the only court they have. And so if they ever want to be a plaintiff in that court, they're going to have to waive. But if a case presents itself in a way that they want to withdraw the waiver, they have a fear of it repeating.
so let me address several aspects of that, please. First, as a factual point, this notion that it's the only court they have, it goes to the speculative nature of all this. The town could certainly establish its own court system. In fact, in 2009, the town enacted a judicial code and set up a court system, and that's referenced in footnote 59 of the Mvskoke Creek Nation Supreme Court opinion. The town has chosen not to fund that court. It certainly could, and the town has all manner of business enterprises. It could fund the court. The Alabama Casarte town, which is one of the other similarly situated Mvskoke Creek towns that is federally recognized, it has its own court system. So it's certainly not the case that as a factual legal matter that the only recourse for the town is to come into the Mvskoke Creek courts. And when we're talking about speculativeness, whether they establish their own court system or whether they continue to use the Mvskoke Creek court system, no one can say. And that's part of this. Secondly, and this is very important, the delay point, I want to speak very strongly to this. I do not think it is fair to say that the Mvskoke Creek courts have engaged in any form of sham here to evade jurisdiction. The delay was extremely unfortunate, and the Mvskoke Creek courts have addressed the root cause of that delay. When the case was remanded by this circuit in 2014, it was assigned to a district court judge who unfortunately, and this happens sometimes, just sat on the case. And several years passed, and that was inexcusable. But when the Mvskoke Creek Supreme Court, in the exercise of its supervisory authority, became aware of the situation, it first urged that district court judge to decide the case. When it became clear that that was not going to happen, it reassigned the case to a different district court judge. That reassignment took place in November of 2020. By May of 2021, that district court judge had issued her decision and then certified the case for interlocutory appeal. The Mvskoke Creek Supreme Court accepted the interlocutory appeal, and by February 28th of 2022, had issued its decision. And on remand, 1 week later, the district court dismissed both cases.
So this was a normal course of events, right? Is that's what you're arguing, that voluntary cessation wouldn't apply unless there was some unilateral action, which we can't find here.
That's exactly what I'm saying. And then that's the phrase that's used in this course Washburn University case, where it says if things happen in the normal course of events, like a court issuing a decision, the voluntary cessation exception does not apply. It's not unilateral. The court here did it.
Could the Mvskoke court refuse to hear a town case?
Yes, it could, Your Honor. And it's interesting because there was a lot of debate within the Mvskoke Creek court system about whether it should even entertain this case. And originally, the Mvskoke Creek District Court had ruled, no, you know what, this is a matter of town law. I don't want to have anything to do with this case.
What's the town do if the Mvskoke refuses to take a case?
Well, look, this is my personal opinion, but I think what the town should do is establish, the town's a federally recognized tribe. It should have its own court system. That's part of exercising sovereignty, and it's done a lot of the spade work for that. Simply a question of funding the system.
Thank you, counsel. Your time has expired. Mr. Salem?
Good morning. May it please the court, I'm Michael Salem. I represent the Thlopthlocco Tribal Town. This case involves an important question for Thlopthlocco, and that's an intrusion upon its sovereignty by the Creek Nation courts. It's important enough that 6 members of the 10 members of the Thlopthlocco Tribal Town Business Committee have traveled to attend this hearing, and they're seated here in the courtroom. As Justice O'Connor in the 3 affiliated tribes versus Wold said, the common law sovereign immunity possessed by a tribe is a necessary corollary to Indian sovereignty and self-governance. Respectfully, contrary to my friend's assertion, this case is not moot. Just because the Creek tribe says that they're no longer exercising jurisdiction over Thlopthlocco doesn't mean that this case is moot for that circumstances. And in addition to that, they made an assertion, and it was repeated, that in the amended complaint that there was no reference to the ability to withdraw the complaint or to withdraw the consent that Thlopthlocco entered into. I might say that it's in their appendix, and in page 67 of the claims, it says Thlopthlocco is entitled to sovereign immunity as a Creek tribal town. On page 68, Thlopthlocco's withdrawal of consent, and that issue is raised, and that was part of the issue, and so therefore any consideration that this was not part of the case would be incorrect. In fact, in the claims, Thlopthlocco said, we want to enjoin the exercise of jurisdiction once Thlopthlocco had withdrawn its consent. I might say that in the previous case, in 2013, when we argued it, this court's decision in 2014, this was an important topic. I mean, it's not exactly like there was some kind of dispute over what that is.
But why can't that issue be fully litigated in a future case where we have a live controversy?
Well, first of all, the question is whether Thlopthlocco raised it. First of all, if Thlopthlocco has raised it. And second, does Thlopthlocco have standing? The district court found that this was a live case because the question for Thlopthlocco is, before they go into the Mvskoke Creek Nation and try to litigate this particular issue, they're burdened by the rule of decision that the Creek Nation has already asserted that Thlopthlocco cannot withdraw its consent under their procedural rules. And so that is part of a live case. I'm sorry.
There's an issue with the underlying merits decision of whether you can withdraw your waiver of sovereign immunity that is very fact-specific. If I look at our case law and the case law generally, whether you can withdraw your waiver of sovereign immunity in this case may be very different than whether you can withdraw it in the next case, because it's very much dependent upon those circumstances. How long has the case been being litigated? Are you withdrawing your consent to or your waiver of sovereign immunity because you looks like you're going to lose and you're trying to game the system? If you look at the case law, it's a very fact-specific decision, so I'm not really sure that you can get a ruling that is a black and white ruling, whether yes, you can withdraw it once you've given a waiver, or no, you can't. How do we deal with that?
Well, the district court judge certainly thought that Thlopthlocco's action in meeting the standards for the declaratory judgment under the Moon case did not think that there was any kind of fencing or of the other 5 factors that were involved. And so I think what's clear is that if Thlopthlocco had standing, for example, to bring a new case, and in reality, these are the same facts that existed in this case at the time.
I think we're miscommunicating.
I'm sorry?
Your point is it's not moot because giving us an answer on this question could govern how we behave in the future. And if you don't give us an answer, it might actually chill our ability to come into court.
Well, okay.
And my point is you can't give an answer based on the facts of case A that tell you what's going to happen in the future cases because it's incredibly fact dependent.
Well, in this particular instance, though, all the questions were there. And what will burden Thlopthlocco in the future is if the district court's decision is reversed, then Thlopthlocco, before it uses the Creek Nation courts, which get funding on behalf and as a part of Thlopthlocco's headcount, Thlopthlocco will be burdened with the decision of, do we go into the Creek Nation courts and assume a possible delay of 16 years, let's say, and, that's a decision we make before we even begin to raise the issue. I mean, in all honesty, in the merits of this case, the question of the dangerousness or problems with Nathan Anderson were resolved 58 days after the lawsuit was filed in the tribal court, when Thlopthlocco on August 8th, 2007, filed a notice of internal resolution. And at that point, if it's confronted in the future, and I'll give you an example, just about October 1st, Nathan Anderson announces in the Mvskoke newspaper that that Thlopthlocco was going to hold an election. He called himself a Thlopthlocco spokesman. I'm not going to go into this with any great detail, but if Thlopthlocco was to go into the Creek Nation court and again wrestle with Mr. Anderson over this issue, and there's some possibility of response, cross-claims or whatever, they have to decide, do we do this and this is delayed and we run into this problem? I might say, though, that after consultation with the Creek Nation and, of course, with council, we resolved that issue because they were going to provide a space for him for this meeting. They withdrew that. The newspaper issued a correction. But if we had to sue him again, the first thing that we consider is not whether we have a cause of action against him, but do we want to go into court where we would not be allowed to withdraw our waiver or consent to sovereign immunity?
Well, and my point is, you have no idea whether you can withdraw it, even if you get a ruling in this case, because it will be dependent upon what has happened in the current case.
In this particular case, the district court entered an order that said that Thlopthlocco had sovereign immunity, Thlopthlocco could consent to jurisdiction, and Thlopthlocco could withdraw that consent under appropriate circumstances.
Right.
That's the holding of Beers. That's the holding of Iowa Tribe in this court. I mean, Iowa Tribe, of course, is this court, and those are standalone questions that give guidance in the future to anybody else, and there's nothing that dismisses those particular holdings from being precedent in the future. And so under the circumstances, the guidance that the district court gave in its decision will control Thlopthlocco's ability to decide whether to waive sovereign immunity and avail itself of the Creek Nation courts, just like Beers does, just like Iowa Tribe does. And I might add that the whole idea that Thlopthlocco can't withdraw its consent as a plaintiff, which was raised by the defendants as if that was some great difference. Ordinarily, a plaintiff has a greater control over its, as the master of its complaint, as to when it consents and whether it, it dismisses the case or whatever. But the district court in the tribal court, the district court in this instance issued a ruling that it had properly exercised jurisdiction over Thlopthlocco all these years. And not only that, even though Thlopthlocco had withdrawn its consent, the tribal district court said that, went ahead and assumed jurisdiction and decided the case. If it did not have jurisdiction, and Thlopthlocco's consent was good, if it did not have jurisdiction at that point, it's supposed to announce the fact that it doesn't have jurisdiction and dismiss the case at that point. But no, it assumed jurisdiction and ruled that Nathan Anderson was no longer a threat to Thlopthlocco. And that was an assumption of jurisdiction contrary to the very rule that we've been talking about. The question is whether that this is a live case, and the federal district court properly found that it was a live case.
Counsel, can I ask you about the district court's analysis here, which skipped over, it seems, the question of subject matter jurisdiction and went to mootness, didn't talk about ex parte Young. Do you think that we have an obligation to do that here? We can't rely on the 2014 case to satisfy our own independent obligation to make sure that we have subject matter jurisdiction, right?
Well, it's always an obligation of a court to decide that it has subject matter jurisdiction. And I'm not going to say that the district court necessarily skipped over it, but I do think that her analysis would be, if she adopted the view that we had, she said that they never decided the question. I said that they did decide the question. That was part of the briefing that I entered. They did decide the question, that is, the tribal district court. The Supreme Court affirmed it. And so we have a very clear rule of decision that affects Thlopthlocco any time in the future that it wants to go into court. It's going to still be subject to that rule. And if they didn't give up the rule that Thlopthlocco could not withdraw a consent once it's given after the remand in 2014, then I think it's fair to say they're never going to get it. And I think that that was subject matter jurisdiction because it addresses the issues of standing, that there was a live case and Thlopthlocco had a concrete interest in the resolution of this question. And so that is, necessarily what you have in terms of subject matter jurisdiction. I might also add that the district court's decision, fairly characterizing the standard of review, is abuse of discretion as to the prudential issues. And it requires a very strong showing by the defendants to show that the district court abused her discretion when she made her decision about how she would treat the question of prudential mootness. And she made findings. I'm sorry.
You also have to have it be constitutionally not moot, right?
Yes, ma'am.
And the district court relied on the capable of repetition yet evading review exception to mootness by saying that this is an election case. That's wrong, isn't it?
No, I don't think it's entirely wrong because it arose out of a case, but I think that she was very true to the idea of something that's capable of repetition yet evading review.
Well, if it's not an election case, this issue could come up in any case, right?
Yes.
Any case where the town was the plaintiff.
Yes.
This case could arise.
Just like the example that I gave, if we were to sue Nathan. But the most likely occurrence is going to be an election case.
But that's not the test. The test isn't most likely occurrence. The test, it has to be that it is always incapable of determination during the time that the case would last.
Well, under the law, there doesn't have to be a certainty of repetition. There just has to be the possibility of repetition. And capable of repetition would be satisfied if, of course, every time Thlopthlocco files a lawsuit in the Creek courts, which, as you've indicated, that's the one that basically that the federal government has supported. Every time they do that, they must confront the issue that they would have to waive this, they would have to waive the ability to withdraw their consent. And that's an infringement on their sovereignty. And that is irreparable harm on page 29 of the book.
Can't that be litigated when it happens?
Pardon?
Why can't that be litigated when it happens in the future? I mean, how is it evading judicial review?
It's evading judicial review just because it took 17 years for this case to come to this point where the defendants avoided this court's 2014 order. The court asked it to provide some explanation and some reason for why it was, for why they were not following the Beers case, and of course the Iowa Tribe versus Salazar case.
Okay, well, could couldn't you or the town have, I mean, we got an explanation of the delay. Couldn't the tribe have asked for a mandamus to have the court issue an order more timely?
Yeah.
I just don't see how you cannot fully litigate this issue in a future case.
Well, I mean, as the old saying goes, you know, attorneys have deadlines, but courts don't. And, you know, what was I going to?
that.
Huh? What?
Continue.
Yes, sir. You know, there was a report filed with the federal district court quarterly, and that went on for years. And this was done with the knowledge of the Creek Nation's attorney and me. I generally prepared them. They okayed them. I filed it in the district court. Finally, after a while, the district court ordered me to file all of those in the previous 2013 case. And I got a question from the clerk when I did that, you know, but what was I going to do? They'd already turned down 2 appeals, you know, which of course was completely inconsistent with Thlopthlocco's sovereign immunity. Twice I appealed, twice it was rejected. And was I going to aggravate or, you know, sort of stir the pot by trying to file another motion? I mean, I tried to do what I could.
Understood. Well, thank you. Your time's expired.
Thank you, Your Honor.
Counselor excused. Did you have any rebuttal time? No. Looks like we're out of time.
Still a minute, Your Honor?
Sure, you can have a minute,
Thank you.
since you asked nicely.
I'll make three quick points. First, in response to Judge Rossman, yes, absolutely, there's an ongoing obligation to assess whether there's still the basis for ex parte Young jurisdiction. I'm not saying this by way of flattery, but in 2014, I think this court got the issue exactly right. But facts have changed. There's no longer an exercise of jurisdiction. And with respect to this question that's still hanging out there, I think you're absolutely right, Judge Tinkovich. That can be addressed in a future case. There's no reason why it can't. And as Judge McHugh said, it's a very fact-specific question. So the guidance that the district court here provided is no guidance at all. Under appropriate circumstances, I don't see how that helps anyone in terms of this concern. The town's concern about what might happen in the future fits squarely within what the Supreme Court said in the Jackson versus Women's Whole Health Center case, which is that the concern of a litigant about being inhibited or chilled in future litigation is not a basis for ex parte Young jurisdiction in this case. And then finally, with respect to the mootness exception for evading review, Judge McHugh's absolutely right. This is not an election dispute. The only basis for federal court jurisdiction here, and the court said this in 2014, is to assess the federal question as to whether the Mvskoke Creek towns were properly exercising jurisdiction over the town. That's the only question that this court has authority to review. It does not sit as an appellate court of general review over tribal courts. And that issue is clearly not one that is inherently short in nature. In fact, there have been questions today about how long this case took to resolve. The case became moot because the Mvskoke Creek courts ruled in favor of the tribal town. They gave the tribal town all the relief it sought, and for that reason, the case is moot, and there is no basis for ex parte Young. Thank you very much.
Thank you, counsel. You are now excused, and the case is submitted. The court will be in recess until tomorrow morning at 9 o'clock.